Okay, so we are revisiting right now the Jason Van Dijk trial in anticipation of the new trial that we're covering tomorrow. The officers who are claimed to have tried to cover up what really happened that night, and that they falsified their reports in order to make it look like Jason Van Dijk was justified in shooting Laquan McDonald. So there's a lot to discuss and a lot to break down, and joining me right now in studio, not on Skype, we have a very special guest with us, criminal defense attorney Andell Brown. Andell, great to see you.
Great to see you, Jesse.
And
always a pleasure.
Always a pleasure, and happy Thanksgiving. I'm happy you're here.
Thank you. Thank you. Happy Thanksgiving to you as well.
Now, I got to tell you, when we listened about the idea of these 3 officers being charged, it sounds like something straight out of a movie. Have you ever seen anything like this before? Because, yes, under cross-examination, we kind of get the flavor of investigations are botched or there's bias. But to charge these officers with these crimes of trying to cover it up and falsify reports, have you ever seen anything like that?
This is extraordinary, Jesse. This is not something you come across every day. The fact that these officers are being charged, I think, is a reaction to what we've seen in so many other cases around this nation. We had Walter Lamont Scott in North Carolina, where that officer said that he tried to grab his taser. The video showed that the scene was set up and it was staged. We had an officer convicted in Baltimore of planting drugs and trying to recreate a scene for an arrest. So this is one of the first times where we see not only the officer that was responsible for the killing being charged, but we have the other officers who wrote reports with facts that the prosecution is saying weren't true being called to justice. That is not something you see every day. It's extraordinary, and like you said, it sounds like something out of a movie.
I'm confused, though. The prosecutors are saying that all 3 falsely claimed in their reports that Laquan McDonald had battered, assaulted, and attacked Van Dijk. Did they not see the dash cam footage? I mean, how does that work? How could they honestly have written that and then see the dash cam footage unless they are going to argue in this upcoming trial our perspective was a lot different than what was in that dash cam footage?
Well, I'm sure that's the argument they're going to give, but the reality of it is most of the times, 99.9% of the time, the officer's word and whatever they write in that report isn't challenged. In the Laquan McDonald case, that video didn't come out after several years of litigation, and when a judge's order said that it was going to be released, all of a sudden we had the arrest and other things that came with that. But before that, no one challenged it.
Let me get this straight. You're saying that when officers write their reports, no one second guesses it, no one looks at it, they just take their word for what ultimately happened there?
That's what happens a lot. Most cases are settled by plea. Most cases, the judge, the prosecution, they're going to look at what the officer wrote, they're going to file charges based on that, and most cases are going to be resolved by way of a guilty plea. It's the small percentage that actually go to trial where the evidence is actually challenged that we actually see that there are other sources than what the officer says about the facts of the case.
Are you surprised that charges were brought against Van Dijk and now these officers?
I am surprised, but I'm not totally shocked in a sense that there has to be some type of accountability when we give that type of trust to an officer that we believe their word. And when they don't tell the truth and justice is on the line, then we need to hold them accountable.
Wow, this is going to be a pretty incredible case to follow, and I'm glad you're here. Yeah, I'm glad you're here to break it down. We're going to talk more about Van Dijk. We're also keeping a very careful eye in Georgia for the Ryan Duke trial, the Tara Grinstead disappearance. A lot of pretrial motions are going to be made today, and as soon as it goes live, you know what we do here. We're going to go live. But in the meantime, let's take a quick break. When we come back, there is a lot more to discuss. Our first day back from Thanksgiving. We appreciate everyone joining us. So we'll be right back right after this. Stay tuned here on Law and Crime. Okay, so the audio's a little choppy right there. Maybe it'll get fixed up in a minute, but we got so much to talk about with the Ryan Duke case. Again, I'm back here with Andell Brown to talk about this. Andell, what are we expecting today with these pretrial motions? Because usually they're more technical, they're kind of boring. This is really important. So can you break it down what's happening today?
Absolutely. We're going to see the lawyers from both sides bringing their best arguments to convince the judge to see things their way. As you stated, there's some very important issues at hand. The statute of limitations issue, if the defense wins that, that means some or all of those counts could be dismissed. So you know that's going to be very important. And I think you also touched on the fact of the order of the arguments in closing statements, as well as whether or not they're going to get a change of venue.
Let's start with change of venue, right? So how difficult is it to get a change of venue here? Because people know about this case, and I'm not just talking about in Georgia, they know it throughout the country, partly because of there's been so much media attention from podcasts and different programs, including the Up and Vanish podcast. The idea of saying, hey, we know about the case, we know about what happened, but it's not going to influence our decision. These are the jurors. I mean, is that real? Is that actually a possibility?
I think that's real, Jesse. Jurors, in my humble opinion and in my experience, they're smart. They want to be fair. They want to do the right thing. And what we want to be able to tell, and obviously they're going to go into that, is whether or not you can get fair people in this jurisdiction. Just because they know about the case or they've heard about it doesn't mean that they can't decide fairly. So it's generally difficult to get a change of venue. And I think you touched on another point. It may be the same if they go anyplace else because people have heard about it all around the country.
Yeah, it's one of those cases. I was thinking back to Paul Manafort, right? So when we trying to get a jury that, who's Paul Manafort? Not going to happen, but you know what I mean? So here the idea, though, let's say they don't get a change of venue, they stay where they are. Trying to get multiple counts dismissed because it's been so long that she disappeared in 2005, and there's an argument to be made that these two people that were indicted, Ryan Duke and Bo Dukes, again, no relation, that maybe investigators could have brought charges against them at a much earlier date, that they were in fact suspects at a much earlier date. Is that a valid argument to dismiss charges? Because it's my understanding, doesn't matter how much time passes, if you can prove somebody is guilty of murder and trying to hide a body or just make someone disappear, though, you can always bring those charges.
And I think, Jesse, that's what it's all about. When it comes to murder, there is no statute of limitations, and especially in Georgia. If that they committed the murder and the state can prove it, then that's it. If it were a different count, let's say theft or some other random felony or misdemeanor, then they have a certain amount of time where they have to bring those charges. Murder cases take a while to develop. Here you can see there was no body. They had to go through the circumstantial evidence, and they brought charges when they thought they had what they needed to prove probable cause. I don't think that statute of limitations argument is going to fly.
Okay, you mentioned an interesting point. The body has never been found. Doesn't mean that they can't prosecute, but how can they get a successful conviction without a body?
Those are always the weakest cases when you don't have a body. The body tells us a lot. It can tell us about the manner of death. It can often identify who may have been involved when you get DNA from another person off a fingernail or other parts of the body, if there was any type of sexual activity between the alleged victim and the defendant. All of those things the body can tell us. They don't have that here. It can tell us around when exactly their death occurred. So the prosecution has their work cut out for them.
Listen, we live in 2018. Technology today is fantastic. We can have all these different ways to analyze what happened. So how does somebody, then again we go back to 2005, right? How does somebody really make a body disappear? Not a trace, nothing. Nobody's found anything in 13 years to find out where her body is, how it was disposed of, what's going on. I mean, really, is this a rarity?
It is a rarity that you have a case, you have a defendant, and you have someone charged with murder, and the prosecution or the detectives, the investigators, they don't have the body. They don't know where it is, and they can't find it. That's something that doesn't happen often. And that's why, just the way you stated it right there sounds a lot like what a defense attorney would get up and argue. How is it we're in 2018 with all the technology we have and we still don't have a body? I think the answer to that question, if you're the defense, is that we don't have a crime. They're jumping to conclusions, and they're trying to make up for the fact that they don't have a case.
Now, again, we're waiting to go back live into that courtroom where all these pretrial motions will be made in the Ryan Duke courtroom, but we can't forget the fact that Bo Dukes, again, no relation to Ryan Duke, just a confusing coincidence here that they both share a very similar last name. He was indicted on charges including concealing a death, tampering with evidence, and hindering apprehension of a criminal, and he's probably going to face a trial at a later date. Is there anything strange to you that 13 years later, these two people are charged, when if you read back into this story, they may have admitted to being involved in her disappearance back in 2005 or a much earlier date? So why is this all happening now?
Well, I think you stated we're going to have an interview with the person who shed a lot of brand new light on this disappearance and really brought it to the public's attention. And it seems like some of the things they overlooked back then, all of a sudden they said, you know what, this fits together. We kind of have a better understanding of how this happened, and we think we have a better understanding of who did it. And sometimes cases are like that. The public eye and interest, it causes investigators to look at the case with a fresh set of eyes.
Is that why more cold cases are heating up today than ever before?
Absolutely. As we, and the media is powerful, the power of social media, the power of blogging, the power of podcasting, where you can reach the people, and as more and more people become interested, it kind of has that effect.
Yeah, it's interesting when we cover cases today, happening now or a few years prior, how it was very hard for defendants to try to cover up what happened. And now it's interesting seeing crimes that were committed years ago being brought to the forefront in 2018. So technology and media, it does help. Let's take a quick break. We'll be right back. Okay, so it might be a little confusing what's going on based upon the audio and the video. Let's try to break it down, Andell. So one of the things that I think they might have an issue with is the idea of murder being used, the term murder. And I'm curious, the idea of these nuances about language that's actually used by either side, does that really affect a jury one way or another?
I think it matters. It's the difference between whether guilt and innocence, right? If there's a killing, that means someone has died, but to say murder, that means that we've discovered and we've adjudicated the fact that it was an unlawful killing.
Yeah, what I think they're saying is they don't want the prosecution to say that a murder happened, right? And that makes sense, because usually what you hear in an opening statement or even a closing argument is there was a killing, or she was killed. You don't want to say murder because that makes it look like that's the state of facts. She was murdered. Someone committed that murder.
Absolutely, and I think the defense wants the playing field to remain fair. They don't want the jurors to have any preconceived notions as they go into the trial. They should listen to the evidence, listen to the facts, listen to the testimony of the witnesses, and make the conclusion about whether or not there was a murder after they have all the facts, the information, and the judges instructed them on the law.
One of the weird things, and I know motive, not an element of a crime, you don't need to prove motive, but one of the things that we have to ask is, why would Ryan Duke do this? And we believe that he was a former student of Ms. Grinstead. Have you looked into this and saw something along the lines of that he became obsessed with her? I read a little bit about it and saw that he had an obsession, or an alleged obsession with her, and that he actually liked another teacher of his and tried to message her on Facebook. Interesting discussion. I'll tell you what, we'll talk more about that. Let's go back live into the courtroom. There's more discussion happening right now. Okay, so one of the issues really is, can you use the term murder when you speak to the jury? And Andell, I mean, it seems to be a big issue here, because if the jury hears murder from either side, are they automatically going to be compelled to say, hey, that's what we got to find out, who committed this murder?
Right. Well, if you got a murderer, you got to have a murderer, right? And there's only these people sitting here at the defense table. So that's an issue that they're going to hotly contest from the defense side, and rightly so.
Yeah, all right. Well, you're seeing that live feed, a lot of motions, a lot of things to consider, because we are going to wait for how this trial will be dictated, and more importantly, where it's going to be. We know that change of venue is a big issue in this case as well. A lot of media attention being brought to this trial, and the question is, what happened to Tara Grinstead, and will we ever have more answers? Maybe we will. Let's take a quick break. We'll be right back here on Law and Crime. Motion after motion after motion. I'm back here with Andell Brown. Now, is this unusual to see so many motions? We know 35 motions. They've only agreed to about 7 or 8 of them. I mean, is this normal practice to see this motion after motion after motion?
That's a whole lot of motions, Jesse. When I look at this case, it's uncommon to see them all being heard kind of at the same time. Usually throughout the life cycle of the case, you have several motions, and a lot of the motions that I'm hearing, they seem to be routine procedural matters that should be able to be agreed upon, such as whether or not there's going to be investigative costs granted, or whether or not witnesses, the defendant's family are going to be able to attend the trial. All that stuff should be sorted out. But there are some very meat and potatoes motions that are out there as well, and we're waiting to see what's going to happen with those.
And yes, certain defense motions, they're basically saying that they just weren't articulated with the right amount of legal and factual specificity necessary. And because if you can't prove your case by the prosecution, if you don't properly articulate it, failure to state the proper claim here, you might get it tossed out. I know it's very specific, but it's important nonetheless. Now, I think we have to take a quick break. Yes, we do. So when we come back, we'll be live in that courtroom, and Andell and I will break down more of the Tara Grinstead Ryan Duke case. We'll be right back. Okay, let's try to break down what's happening right now. We know, Andell, they're arguing about several motions, several counts in the indictment: malice murder, felony murder, and aggravated assault. And the defense is basically saying it's not entirely clear, based upon the wording of the language, what our client was even charged with. Have you ever seen an argument work this way? Has it ever been successful in trying to get a count dismissed?
I've seen many cases work this way. And just for due process procedural reasons, if it's not clear what the crime is, you can't defend against it. And there have been a lot of counts that have been thrown out. I've used it successfully in some of my own trials, where you can't tell the difference between the legal and illegal activity in order to defend your client. The prosecution, they bring the case, it's up to them to make it clear what they're alleging and what we're fighting against.
Okay, that's pretty interesting. Let's go back live and maybe we'll learn a little bit more about what's happening. Okay, so this is fascinating. Andell, first up right now, what they're arguing is, how can you specify what happened to Tara Grinstead without a body? So how can you charge our client with assault when maybe that didn't even happen? Am I understanding that argument correctly about why they want these counts dismissed?
I think you are, Jesse. I think part of the issue, whenever you talk about an aggravated assault, how did it happen? What was used? In order for there to be an aggravated assault, you have to have either serious bodily injury or there has to be a deadly weapon used. They haven't specified what type of injury was caused, and they haven't specified the weapon that was used. I think the prosecution has tried unsuccessfully to argue that the hand, by saying hand, they've met the burden, but I don't think that's enough.
Yeah, and it's interesting because it could go both ways, where the judge said, well, since they don't have a body, they have to argue one way or another. And then the defense is saying, well, that's the very point. There's no body. You don't know what happened. But the other interesting argument that's being made is whether the delay in pursuing the suspects was an oversight on the part of law enforcement due to the fact that this case changed hands so much over the years. But in your opinion, is that grounds to ultimately dismiss some of these charges? The fact that they could have been charged at an earlier date, that they were on law enforcement's radar. I'm talking about Ryan Duke and Bo Dukes. But we're in 2018, and this happened back in 2005. Is there a legal argument that these charges could ultimately be dismissed because of that?
I think there is a legal argument there, Jesse, and it depends on the particular counts. I think for the murder count, there's not going to be a statute of limitations issue with that. But there are other counts. There's the assault, there's the burglary. Those counts has very specific time periods in which the state has to bring charges. It doesn't look like they brought them now. So I think the defense has some strong arguments to be made on those counts. I
got to tell you, usually we cover these motions and we're like, you know, it's kind of technical. It's not that much interesting. This is fascinating, and it's kind of determining whether this trial will go forward, how it will go forward, where it will be held. Fascinating stuff. Let's take a quick break. When we come back, we'll be live in that courtroom. We're talking about 35 motions that basically have to be decided. About 7 or 8 we're getting reports that have been agreed upon, and we're waiting to see whether or not the judge will actually decide upon any today, maybe tomorrow, maybe after trial starts. Really interesting stuff. We'll take a quick break. We'll be right back. So the question really becomes, can you properly charge the defendant in this indictment, because the language might not be sufficient, especially with aggravated assault, because we don't have a body. We can't tell what happened to Tara Grinstead. And we're going to talk about that issue in a second, but Andell, one of the other important issues that we think is going to be argued is that the defense said, let's throw out this entire indictment because the way the grand jury was selected was improper, inadequate, and actually had a discriminatory effect, since underrepresented groups were not positioned in that grand jury. That's an interesting argument, trying to throw out an indictment because you didn't like the way the grand jury was composed. Have you ever seen anything like that before?
Jesse, I have not. That's my first time hearing about that, and I'm excited to see how it's going to turn out. The fact that they've gone so far back as to look at the way that the grand jury was selected and how that affects their client and their ability to get justice, I mean, that's my hat's off to those defense attorneys. I want to see what's going to happen here. I think it's going to be a great, stunning development in law.
I'm curious if they can get some or all of the indictment thrown out. I mean, he's charged with 6 different counts, including malice murder and felony murder. And here we're talking about aggravated assault being thrown out because, again, with no body, really, how do you specify the crime? That there's going to be no medical examiner testifying in this trial. So have you ever handled these kinds of cases before where there is no body, you can't tell what happened?
Yes, we've handled many cases like that, and usually what the state is relying on is the circumstantial evidence. They're saying, look, you know, the fact that there is an alleged confession that was made in one day where they were intoxicated talking to some friends, they're going to go with that. They're going to go with the obsession that they said Dukes had about a former teacher and his other strange behavior to try to put it all together and make a case. But one thing is clear is that the prosecution has their work cut out for them, and the defense is aggressive and ready, and I think they're going to be successful in at least some of those counts.
All right, well, we got a lot more to talk about. Let's take a quick break. We'll be right back. Okay, let's try to break down what's happening here. Obviously, Andell, the bigger question is what's aggravated assault here, and how do you properly define it when you don't have a body? You don't know the injury sustained by the body, if wherever the body is. So the idea here of trying to what is aggravated assault, and if you don't have a weapon and use a hand, can you explain a little bit what the nuanced approach here is happening, what the defense's ultimate goal is?
Sure. I mean, look, the difference between simple assault, which is a misdemeanor, and aggravated assault is whether or not you have a deadly weapon or there's serious injury that's caused by the assault. In this case, they're saying that the instrument used was a hand. A hand can be used in a simple assault, which is a misdemeanor, or a hand can be used in a felony assault, an aggravated assault, without describing the injury or that it was used in a manner that could cause serious injury, bodily injury or death. It's hard for them to say that this is actually the felony category of assault, and I think that's what the defense is arguing. They're saying the state has not specified which way the hand was used in the indictment, so that type of vagueness is unconstitutional because it's not a crime it's not the crime that they're saying it is, a felony assault, because they're just saying they used a hand. A hand can be used in a simple assault.
And a practical point of view, though, right? Even if they get the assault charge dismissed, you're still looking at felony murder charges and malice murder charges. So what does it matter?
Well, you know, I think you want to get everything that you can dismiss as a defense attorney. You never know what happens on appeal. Those murder charges, if they were convicted, they may be overturned on appeal. And if you still have those other convictions there, that person can still be sentenced to prison for those. So you want to get everything out that you can. You don't want to leave anything lingering.
One of the things that we brought up at the beginning part of the program is we believe prosecutors have agreed to move the trial in this case. The judge, I think, still needs to weigh in on that. Why would they agree to that?
Well, looking at this incident, we had a very small town where this case was big news. I mean, there were billboards all over the town looking for this woman when she was missing. So it seems that a lot of people in that particular town have formed some opinion about what they know about the case. Obviously, word travels. You know, there are rumors and other things that are out there. This was a teacher. These were former students. That's the sort of thing that over time, the legend can become bigger than the facts, and I think that's what the prosecution is admitting to here. They think that could be the case. That's what the defense is arguing. We have to see whether or not the judge agrees.
You think this trial is going to move forward?
I think it will move forward. I think even if the aggravated assault or some of those other counts go away, the murder charge has enough for it to go forward to trial and for a jury to decide whether or not these men are guilty of murder.
Right, and so it should be noted that we're covering Ryan Duke's trial, right? He's charged with the murder. Bo Dukes is charged with trying to cover it up and concealment of the body. those are two separate trials, right? And in other words, is it very dependent what happens to Ryan Duke to ultimately see what happens to Bo Dukes? Again, no relation between them.
Right. I think each trial will have to stand on its own, and each case will have to be proven on its own. If one is acquitted, it does not mean that the other one can't be convicted or vice versa. So we have to follow each trial and see what happens and what the evidence is presented as to either Bo or Ryan Dukes.
Again, we're trying to understand why this happened. We're trying to understand what happened to Tara, and if in fact these two men are responsible for her death and disappearance, the question becomes, what was the motive here? Now, one of the weird things that when you read about this case is, as you said, they're former students of Tara Grinstead, who was this beloved history teacher. The idea that Ryan Duke may have been obsessed with her, and there's reports that he also tried to contact another teacher at some point through Facebook saying how sexy he thought she was. This idea of that he became obsessed with her, and that's what would instigate him to kill her. Can you explain that? Have you seen something like that? That teacher-student dynamic or anything like that before?
Well, you know, the teacher-student dynamic is always one that we'd be eternally interested in. I think almost everyone can remember at some point, you know, having some type of crush on the teacher, and we've seen numerous cases where that kind of crosses a line into romantic involvement. But I don't think that that alone is all it's going to take to establish motive. As you stated before, Jesse, they don't have to prove motive in order to sustain a conviction for murder, but it's still an interesting question to be answered. The fact that he did, as on what was it, Facebook, he kind of slid into DMs and he shot his shot. Look, that happens. I can't blame him for that. That doesn't make him a murderer. But I think the facts of these cases have to be determined on their own. And the motive, we all want to know what it is, but I don't think we'll ever find out fully. One of the questions also is whether or not Bo Dukes, again, no relation to Ryan Duke, somehow is maybe fabricating the story, or somehow there's not information that will fully make sense that he's now turning on Ryan Duke when maybe he's the person who's ultimately responsible. I mean, again, we're trying to understand what happened here. The idea of you have two people, how they're connected, and who's ultimately responsible. I'm curious your thoughts. Yeah, well, look, as a defense attorney, if I was representing either one of them, I would be happy about the fact that there's some gray area. If there are questions about who's turning on who and who knows what and who did what, that goes to my benefit because the state has the burden of proof. Very well said. Andell Brown, thank you so much for coming in. Go back to your beautiful family. Happy Thanksgiving and safe trip back to Miami. Thank you, man. Have a great day. All right, everybody, let's take a quick break. When we come back, a lot more to discuss here on the network. So we'll be right back here on Law and Crime.